car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the law firm of Hollis, Wright, and host David Lamb.
Hello and welcome into the attorneys. We appreciate you spending your Sunday evening with us. Our topic of conversation tonight is one that's really interesting and affects a whole lot of folks, and that's pesky debt collectors. What is allowable? What is legal? And what are your rights? We're going to deal with that tonight on the show. So we look forward to getting your questions on this matter. You can call, text, email all throughout the next half hour. That information is going to be displayed at the bottom of your screen, and we would love to include you in the conversation. Carter Clay of the firm Hollis, Wright leading the conversation. This really is a subject matter that affects a lot of folks. And boy, some of the stories you hear, and some debt collectors can just be ruthless, can't they?
Well, they absolutely can. And boy, would it be nice if we all just had an endless supply of cash that we could live off of. We could eliminate all of these issues and problems entirely. But that's not reality.
No.
What is reality is that people have to take out mortgages to buy a home. People have to go to the bank to get loans for businesses and personal loans and things like that. People have to get services provided to them, and they have to go into debt perhaps for that. And so as a consequence of that, you have a creditor and you have a debtor. And that's what we're going to be essentially talking about here this evening, because it has broad ramifications throughout the entire United States, throughout the economy. Debt collection and debt in general has been a huge part and is the primary reason why people file bankruptcy. And bankruptcies have spiked over the years. People just want to get the debt collectors off their back. They want a fresh start. They want to try and eliminate the debt. And so as a consequence, bankruptcy is oftentimes the only means by which they can get these debt collectors off of them. But we're going to talk about it tonight. We're very fortunate and glad to have John Watts, a local attorney, here with us. John Watts has been a friend of mine for a long period of time. He does an outstanding job advocating on behalf of consumers and debtors, and we're so thankful to have you here this evening with us, John. Again, thank you for being here. Talk to us a little bit about yourself, your background, and the nature of your law practice.
Sure. Well, I appreciate you having me on. And what we do at my law firm is represent consumers. So, and a big portion of that are consumers that are dealing with debt collectors. Maybe calling, maybe writing, maybe credit reporting. But just a lot of different types of abuse that we see. And the problem is, and this is part of what we're trying to do, and appreciate you having this show, is to give people information so that they know what their rights are. Because if you know what your rights are and you're willing to take action, then good things can happen. But if you don't know that somebody's violating the law, then, as you mentioned, you may think, well, my only solution is file bankruptcy.
Well, and I would think that a lot of what we're going to talk about here this evening will probably surprise a lot of the viewers relative to what can be done by a debt collector and what cannot be done, because I think a lot of people's knee-jerk reaction might be is if you owe somebody a debt, I mean, other than physical harm to you, they can probably do just about anything to try and get you to pay the debt, but that's really just not the case.
Right, but that is a belief that a lot of people have. Well, I owe it, so they can call my mother-in-law or my ex-mother-in-law. They can call my neighbors, my coworkers, and so just knowing that we do have rights and having that knowledge, as long as we'll do something with it, that really gives us power.
Well, being an attorney myself and having gone to law school, I'm going to guess that when you graduated from law school, you probably didn't know that this was going to be the line of work that you got into. How did you get into this line of work?
Carter, I'd like to say that it was a carefully, detailed plan. But my first 10 or 12 years I did very similar to what you do, personal injury. And I just started having clients that might have a problem with their credit report or a debt collector. And a couple of those situations struck me as just being wrong, which is not a very scientific approach, but you say that just doesn't feel right. So start digging into the law and realize, people do have some rights. And I had a personal experience. We were buying a house and got a call from my mortgage broker. And my wife and I are packing the boxes. And he says, John, we have a problem. I thought, no, we can't have a problem right now. I'm packing boxes. And he says, well, there's something on your credit report, and we're not going to be able to do the loan. And so I figured out what it was. It was wrong. And so I called the place that put on there, and they said, well, we're not going to remove it. And I never tell people I'm a lawyer, because that's what I do all day. I don't want to come home and call people on the phone. So I'm a lawyer.
Right.
But I thought, I'm going to break this rule. I said, look, I'm a lawyer. They go, we're not going to change it. I go, I'm a lawyer that sues people. And they still wouldn't change it, so I figured out what I could do, and I finally got it off. We closed on the house. But I thought, wow, what arrogance that they knew it was wrong, but they said, well, just pay it, and then we'll take it off. I'm like, well, I'm not going to pay $5,000 I don't owe. But that's the attitude is, well, there's nothing you can do.
Well, we have state laws out there and we have federal laws out there, and you've kind of got those two parallel tracks in terms of the laws that we have throughout the United States. What are the laws out there specifically that are designed and have been implemented to protect debtors and protect consumers?
Well, the two biggest laws would be the FDCPA, which is the Fair Debt Collection Practices Act. And that's a law that tells debt collectors, here's what you can do, here's what you can't do. And then we also have on credit reporting the FCRA, the Fair Credit Reporting Act. And again, that tells credit bureaus, creditors, debt collectors, whoever's involved in credit reporting, here's what you can do, here's what you can't do. So those are the two primary laws.
And are those federal laws or state laws?
Right, those are federal laws.
And I don't know if Alabama does, but do some states actually implement their own set of standards and rules and regulations relative to debt collection and credit reporting?
They do. I think Florida has a law, basically just tracks the federal FDCPA. Here in Alabama, we really don't have that, so we rely primarily on the federal law.
A question here, what is prevented under that FDCPA?
It's a mouthful.
It is.
For some reason, we love all these initials
do,
and
yes.
acronyms and stuff. Two basic things. One is a debt collector cannot lie. They cannot deceive you. They cannot trick you. And the second thing is they cannot treat you unfairly. And the law is pretty broad. So, when we think about and it goes back to what I said before about having some clients that dealt with this. Sometimes you hear something, you go, that just doesn't feel right. That sounds wrong. Well, it probably is under the law.
Yeah. Put some context in the first component of not lying. Give us some examples in context to that requirement.
Let's say that I'm a debt collector collecting against you, and I say, you owe $3,000. And really, you don't owe the debt. Well, I said you owe 3, and really you owe 0, so that would be a lie. That's deceptive, untrue. If, let's say you owed $5,000, we had a case like this, $5,000, debt collector says, pay us 3, and we're done, we're even. So I got paid 3. And then the debt collector, 6 months later, came back and said, you owe us 2. Well, no, I owe you 0. Because I paid 3 and that solved it. And they continue to say, no, you owe $2,000. Well, that's a lie because we don't owe anything. It can also be, if you don't pay this, I'm going to call the police on you. We don't see that very often, but that would be a lie because they're really not going to call the police. Or say it's a 10-year-old debt and they say, if you don't pay it, I'm going to mess up your credit report. Well, it's too late to credit report. So that would be a lie. So really just anything where the debt collector is saying something that is not true, that's probably a violation of this law.
All right. Time for us to step aside. We'll pick up right there when we get back. Interesting conversation tonight. Would love to have you be a part. Call, text, email, that information displayed on your screen. Would love to have you join our conversation. Also a reminder that attorneys are standing by right now to speak with you, so take advantage of that. Stay tuned. More of The Attorneys coming right up.
I'm Carter Clay with the law firm of Hollis, Wright. Thanks for watching The Attorneys on WVTM 13. Now we hope you, a friend, or a loved one never need legal counsel for a case. But if you do, the goal of this show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to this show or related to other specific legal matters, call, email, or text us to talk with one of our lawyers. You can also follow us on Facebook or Twitter to learn about important legal news that could affect you or your family member. Or simply contact us by going to WVTM13.com and click on the attorney's link. Now, we know your time is valuable, so thank you for spending it with us and for watching The Attorneys right here on WVTM 13.
Welcome back into The Attorneys. Thanks so much for being with us tonight, talking about debt collection, unfair practices, what is allowable, and what are your rights. We'd love to have you join the conversations. If you have a question for us, just email, call, text those questions into us, and we'll pass it along to our panel of experts. Carter?
John, you mentioned before the break that a debt collector, as part of this law, cannot engage in dishonest acts or make dishonest statements towards the debt collector about the debt that they're trying to collect on. And what I wanted to follow up on is, in your practice, do you find that the errors or incorrect statements are based upon problems with the debt collector or the original creditor where the debt was obtained first off, or is it a combination of the two?
It's a combination, but the majority of the errors would be with the debt collectors. And part of that is because usually the debt collector you're dealing with is not the first one. It may be number 4, 5, 6, 8 in line. And so those errors get passed along the chain there.
And why is that you have so many debt collectors in line? Is one debt collector paying another debt collector on the debt, and then they're just passing it on?
Sometimes we really have two types of debt collectors. One, the creditor still owns the debt, and so that's just a traditional collection agency. But we also have a huge industry now of debt buyers, people that they claim to buy the debt. Well, they'll buy it for 3 cents on the dollar. And if they can't collect it, they'll sell it to another debt buyer for 2 cents on the dollar until it eventually gets down, they're almost giving it away. Well, they don't seem to be terribly concerned with keeping real accurate records, particularly if a consumer says, wait a minute, I don't owe that debt. Well, rather than investigate, a lot of times they just sell it to somebody else.
Yeah, and I would think that the debt buyers would actually create or foster this environment of engaging in abusive tactics, because now the debt buyer has actually paid off the debt to the creditor, and now it's them. They want to get the money back from the actual debtor.
Right.
And does that happen from time to time?
It does, and a lot of times what they buy, they know they won't be able to collect. So if you happen to have a job or a house or some assets, they really want to get the money from you. So the temptation is kind of stretch the truth a little bit, go beyond the bounds of the FDCPA.
You had, in talking about the FDCPA, you were saying that it prevents lying and any unfair conduct. You gave examples of lying. What about examples of unfair conduct? How would you define or typify that?
Well, some examples would be, we have something called statute of limitation. That's how long somebody has to sue you. If a debt collector sues you after the statute of limitation, then that's considered unfair. If they are collecting a debt that you do not owe, well, that would be unfair. So that example I gave of the guy that owed $5,000, he paid $3,000. Mm-hmm. Well, not only did they collect against him, which is a lie, but they sued him. And so if we just stop somebody on the street and say, hey, do you think it's okay to sue people who don't owe any money? Well, no, that's not fair to do. So that would be unfair. And that's an argument we just made recently to a federal judge, because the debt buyer who sued us when we didn't owe any money, they said, well, that's not unfair. I'm like, well, what would you call that?
Yeah.
I mean, you sue somebody who doesn't owe the money, that's not fair, it's unfair. It might be calling your neighbors, calling your family members, your ex-mother-in-law, that's always a favorite. And telling those people, hey, so-and-so owes this debt, can you get them to call us back? Well, that would be unfair. It just kind of strikes you at your core that that's just not right to do. Right. To make threats of, I'm going to arrest you, or if you don't pay this debt, we're going to garnish your paycheck tomorrow.
Yeah, John, we've heard stories over the years about debt collectors calling and leaving 55 messages in the course of a week, or calling and mentioning racial slurs on voicemails and things like that. Give some examples, or tell us, what does the law protect the debtor against relative to harassment and calls? Can they call your employer? How many times can they call your house? Can you tell them to stop? Tell us a little bit about that.
Okay, so first thing I'll say is it does not have to be pleasant. Okay, so they don't have to be your friend when they call, because they've got a job to do, collect the debt. That's fine. But the law says you cannot harass somebody. Well, what does that mean? Well, one thing would be if you're calling so much that it's obvious you're not trying to get in touch with the person, you're just trying to blow up their phone. So 55 calls in a week, I think, would qualify as, you're not being nice to this person, you're harassing this person. So a favorite is what we call third-party contacts. So if I owe a debt, the debt collector can call me or my wife, but they cannot call my brother or my neighbor or my preacher or my supervisor unless they're trying to get what's called location information. And that's very specific. It's where do I work, my home address, home phone. It's not how much I make or my email or my cell phone. It's just those three things. So when they call your neighbors and they start saying, well, can you get in touch with Carter because Carter's not calling me back, and then they come over to you, that's called a block party. That's what the debt collectors call it. They say, you know what, he's not paying us, do a block party on it. So when you're sitting there at dinner, all these people are knocking on your door saying, hey, somebody's trying to reach you. Very embarrassing. They call it an office party that they call all your coworkers. And so those are some examples of what would be considered harassment. So racial slurs would be, again, they don't have to be overly nice to you, right, but if they're insulting you, being abusive language, then that's going to be a problem.
Yeah. Let's take a break. We'll pick up right there whenever we come back. Let's take our final break of the evening. As we head into break, a reminder of how you can get in touch with the firm of Hollis, Wright. Call, text, email. Also, you can find them on Facebook. If you'll search that term, just search Hollis Wright on Facebook, and on Twitter, it's Hollis_Wright. Stay tuned. More of The Attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright. If you've ever served on a jury, you may have wondered why there are gaps in the evidence you're given at trial. In today's Legal 4-in-1, we're answering the question, is there insurance to pay the verdict? Know this, just because the lawyers never mention insurance in a trial, it doesn't mean there's not insurance to pay the verdict. Rule 4-in-1 of the Alabama Rules of Evidence states this: evidence that a person was or was not insured against liability is generally not admissible or allowed to be discussed at trial in front of the jury. The reason for the rule is simple. A jury could award more money in a case if they knew the defendant had insurance to pay for. But the reality in our state is this: in almost all lawsuits that get to a trial, insurance is there to pay judgments awarded by the jury. For example, all automobiles in Alabama are required to have liability insurance. Coverage can range from $25,000 up to $1 million in these cases. In theory, all car crash cases that get to trial should have insurance available to pay any verdict awarded in the case. Trucks have to carry anywhere from $750,000 to $5 million worth of insurance. Unfortunately, you'll never hear that during the trial. Even in medical malpractice cases, the doctor has liability insurance to help pay a judgment. That's something you won't hear during trial because the rules just don't allow that testimony. Yet almost all judgments against a doctor involve liability insurance. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our promise and pledge to you. Thanks for watching The Attorneys.
That's a lot of mistakes right there. Welcome back in to the Attorneys. Hey, if you want to join the conversation, just a few minutes remaining in the program. Call, text, email, join our conversation. Get your questions to us, and we'll be glad to pass them along to our panel of experts. Carter?
Yeah. John, does the Fair Debt Collection Practices Act apply to the original creditor that you incurred the debt through, or does it just apply to the debt collectors that are hired by the creditors?
It's a great question. Normally, it does not apply to the original creditor. So we're talking about a debt collector or somebody that has bought the debt. Where it gets a little sort of confusing is sometimes it can be a big company that we think of as a creditor, but it may be a debt collector. So an example would be, if, say, Capital One, so that's a creditor, but they go buy up a bunch of old debt from another credit card company. Capital One may be considered a debt collector.
And so advice to the viewer would be, rather than try and figure that out on your own, if you're getting harassed or if somebody is engaging in abusive tactics relative to trying to collect on the debt, call a lawyer like yourself and you can define what their rights are and who the players are.
Right, and the best advice I can give people is just document what's happening. So somebody's calling you, make a note. Here's when they call, or take a screenshot of your cell phone. But you just want to document what's happening and then talk with us or somebody else who does this. And then we can say, okay, well, that looks fine or it looks illegal. And here are your options.
Question we have here, what benefits does that federal law give a consumer?
Well, it's a pretty remarkable law. It says to a consumer, if you've been harassed, then you can get what are called actual damages to compensate you. Mm-hmm. Now that could be maybe you get fired from your job. Usually though it's emotional distress, mental anguish from somebody calling your neighbors, calling your coworkers. And so the law recognizes that and says, hey, if that happened to you, you can be compensated for that. You can also get what are called statutory damages. It can be up to $1,000. Even if you weren't hurt at all. Mm-hmm. That's the government saying, we cannot regulate these guys. We need you, the consumers, if you're hurt, to go sue, and here's an incentive to sue. And then you get your lawyer paid for it. So it's a pretty good law.
Wow. Talk a little bit about the Fair Credit Reporting Act. You mentioned that at the very beginning of the show, but what is the Fair Credit Reporting Act, and what benefits or protections does it provide for?
Well, it also is a very powerful law. It says to anybody involved with your credit report, you must put accurate, truthful information. I think we had that graphic up on the screen about just a high number of errors. And so we have the credit bureaus, Equifax, Experian, TransUnion. We have what are called furnishers. That might be a debt collector, it might be Bank of America, Wells Fargo. Those are the guys that furnish the information to the credit bureaus. And so it says you have the right to have an accurate, truthful report. If you don't, then you can dispute it. And when you dispute it, if you do it the right way, the credit bureaus, the furnisher, whoever's involved, they have to investigate it and fix it. If they fix it, great. If they don't fix it, then you have the right to sue under this law.
And what kind of damages or claims can be derived from a violation of the Fair Credit Reporting Act?
Well, it's similar to the Fair Debt Collection Practices Act. You get compensated. So, and with credit reports, you might miss out on refinancing a loan. That might cost you $50,000, $100,000. Then you get emotional distress. You can get punitive damages to punish the credit bureaus. And again, your lawyer is paid for typically by the credit bureau. So they got to pay their lawyer plus your lawyer.
Well, now I have actually confronted and evaluated cases in the past where a person called and said that they couldn't get this loan or they couldn't get this mortgage because of this particular item on a credit report that was wrongfully put there. The challenges I face, and you probably face, is proving that incorrect statement on the credit report is why they didn't actually get the loan, as opposed to maybe the 4 or 5 other items that were correctly put on the statement.
It can be challenging, but sometimes well, I'll give you an example. Had a lady, perfect credit, never been late. And suddenly on her credit report are about 50 debt collectors. They mixed her file up, the credit bureaus did. When she gets turned down, we can say, well, the month before she had perfect credit, now she can't get anything.
That's pretty good on causation.
Pretty good. But a lot of times you get the mortgage broker to say, but for that Wells Fargo account or that debt collection account, you would have qualified. And that makes it a little bit easier.
We have just about 2.5 minutes remaining, but just real quick, your 2 best tips, what to do to fix your credit report.
Well, the first thing is you got to pull your credit report to see what's on there. And people often assume they know what's on there. They go, it's really bad or it's really good. Well, I don't know. Pull your credit report. And then anything that's incorrect, disputed in writing to the Equifax, Experian, TransUnion, it'll either get fixed or you sue to get it fixed.
Right. Okay. Good advice there. Less than 2 minutes remaining. Time enough just for some final thoughts, and we'll start with you. Just kind of a final thought, something to leave with our viewers tonight.
Well, I think this program that you guys do is critically important, whether it's in this area or whatever area of the law it's in, because if we don't know our options, we don't know our rights, how can we be expected to make the right decision? And then what our job as lawyers is to encourage people, all right, now that you know what to do, you need to do it.
Right.
Because if we can have all the knowledge in the world, what's that expression? Knowledge is power? No, it's not. It's potential power.
Right.
If you mix it with action, that's when you get good results.
Yeah, David, I think my final thought would have come from a little bit different angle, and that is if you have a debt with a creditor, whatever the business is, communicate with them. I think one of the things that I see oftentimes is people run from the debt. They ignore the creditor that's trying to call them, because a lot of these creditors, if not most of them, they will work out payment plan options with the individual. They don't want to have to turn it over to a debt collector. They want to get paid, and they'll work it out with you if they think that you are being responsible and you're not running from the debt. So communicate with the creditor, try and work out some payment plan options, and you should be okay.
A really helpful show, a helpful conversation. Appreciate you two being with us tonight. I also appreciate you joining us as well. Thanks so much for the time. As we wrap things up, here's how you can get in touch with the firm of Hollis Wright. They get back return every call and every email, so go ahead and get in touch with them. Thanks again for being with us. We'll see you next week right here on The Attorneys.